The Mental Health Act crops up in every area of law in some form or fashion. No practitioner can avoid it. So what happens when an attorney lets slip maybe an inadvertent argument about their client's medical history? Does that make their medical records fair game for inspection or turnover under the Act? Hello again. Before we start, it's pandering time. Every day the appellate court releases new opinions. There's just too many for me to cover. Likes and subscribes help me figure out which ones you want to see more of in the future. But with that said, I am totally ignoring the ratings today and doing this very niche issue because it allows me to kill two birds with one stone. Now that second bird is this channel. Now somehow I have 800 subscribers, which is honestly 800 more than I thought I'd ever get. And the reality of the reality is that more people are watching these. Occasionally, I get emails from people who didn't like that I covered their case, despite the fact that they're publicly available, which means anyone can go online and download them right now from the Illinois Supreme Court website, facts and all. Now, for my attorney audience, these videos are, at best, entry-level CLEs, minus the credit. We read cases the same way doctors study patients. It's a required part of our professional development. But understandably, for the public, having a video out there about their case probably isn't number one on their wish list, especially when, like today's issue, the topic is mental health. Now, this channel's goal is to share Illinois case law. Now, without discussing the facts, it's almost impossible for me to put the case law into context. So if you're close to this case, I guess this is your trigger warning. You can still say that, right? Now, I know it's a Rule 23, but strangely, I can't find an opinion that covers this specific topic. And since it's a post-2021, you can use it, persuasively at least. Bottom line, we have a contentious custody fight. Mom doesn't want dad to have unsupervised time with the kids. She believes there's mental health issues. The judge, actually, I should say Justice Walker, since she was elected to the 1st District last fall, appoints the Jean Genie as GAL. And I have been dying to say Jean Genie since I started this channel years ago. She's one of the most well-known GALs in Cook County. Jean Genie is not her real name. It's actually Jean Condi. When I hear her name, the only thing that pops in my head is the Bowie song. And before I forget, I have to round off today's Who's Who with this guy, Paul Feinstein. He was counsel for dad on appeal, not trial. I've covered a few of his cases in the past, including Yabush, which I hope I'm pronouncing correctly. Back to the case. Mom argues that some of dad's actions were due to mental health problems. It appears both sides agree that dad has medical records, although what's contained in them, nobody knows. Somewhere in this back and forth, dad's trial lawyer makes reference to them, and the opinion suggests it was more than just a passing remark. Based on this and some pretrial statements from the GAL, the judge orders dad's records to be turned over. In response, dad asked to be held in friendly contempt because you generally can't appeal a discovery order except by way of contempt. Justice Walker says, sure, I'll let you be held in friendly contempt, and this appeal follows. So the issue is whether argument by counsel trips the statute. But let me back up just a little bit. The applicable section of the Mental Health Act holds that in a matrimonial case, a party's medical records aren't subject to inspection or turnover, unless dad or one of his witnesses testifies to it, i.e. they open the door. Now, we know that argument by counsel isn't evidence, but mom's lawyer says correctly that a client is bound by the things that come out of their lawyer's mouth. And when dad's lawyer opened their mouth regarding those records, the statute was triggered. But the appellate court isn't convinced that argument without more is going to trigger the statute, and they reverse, at least on this issue. The takeaway, lawyers, we can give argument on our client's medical records without triggering this section of the statute, at least for now. Anyways, that's all I have. Thanks for watching.